A major development is unfolding tonight in America's ongoing immigration debate, and it has triggered urgent conversations across the country. U.S. Immigration and Customs Enforcement has issued a fresh warning about what it calls self-deportation for undocumented immigrants. The agency is pushing out a new national message outlining how people who are living in the United States without legal status may be expected to leave voluntarily before federal officers locate them. ICE is making it clear that those who do not take action could face detention, long processing times, and even multi-year bans from entering the United States. At the same time, a new State Department rule is raising concern across immigrant communities and the tech industry. The U.S. government will now review social media activity of H-1B workers and their dependents as part of visa screening. Together, these two announcements are sending a wave of anxiety from coast to coast. The agency posted a clear statement online telling people who are in the United States without legal status that they may be ideal candidates for self-deportation. In simple terms, ICE is saying that anyone who has no criminal record and no official removal order could voluntarily leave the United States by following a step-by-step process. For months, immigration enforcement has been increasing across multiple states, and, this new public notice appears to be part of a broader federal strategy to encourage voluntary departures rather than waiting for arrests. The agency describes self-deportation as a straightforward action. It means leaving the United States on your own without waiting for law enforcement intervention. Unauthorized presence is unauthorized presence. What is striking about the AY's message is the urgency behind it. IC states clearly that people should not wait for federal officers to come to their homes or workplaces. The agency says locating individuals who are unlawfully present is only a matter of time, not a matter of possibility. With thousands of trained immigration officers working nationwide, ICE warns that those who do not come forward voluntarily could face detention in a federal facility. According to the agency, some individuals wait months before a final decision, and once a formal removal order is issued, they may be blocked from re-entering the United States for years, sometimes even for life, depending on the situation. Because of that, ICC has now released a structured digital method for people to initiate self-deportation. The agency wants individuals to use the CBP Home mobile app, which is becoming one of the newest tools in immigration enforcement technology. Through this app, anyone preparing to depart the United States voluntarily can submit their identifying information, upload a current photo, select their preferred language, and if needed, include details about family members who will travel with them. Federal officials argue that self-deportation is often the simplest path for people who want to avoid a complicated legal case. By leaving voluntarily, individuals can prevent a formal removal order from being placed on their record. If someone chooses not to self-report, federal officers may locate them during enforcement operations. Once detained, they could face long stays in immigration custody, experience restrictions on communication, and ultimately receive a removal order that blocks future legal entry across immigrant communities. These messages are triggering new discussions about legal options, asylum claims, visa pathways, and the risks of overstaying authorized time. Lawyers have noted that voluntary departure is not a one-size-fits-all solution. Some individuals may still be eligible for legal relief, while others may face immediate consequences if they do not follow the instructions carefully. For many families, the decision becomes, really complex. Do they remain and pursue legal avenues, or follow ICA's advice to leave voluntarily to avoid long-term consequences? The announcement has brought these questions to the forefront again. Adding to the tension is, another major immigration update, this time from the U.S. State Department. Beginning December 15th, A new requirement will give visa officials the authority to review the social media presence of H-1B workers and their H-4 dependents. This is a significant development because H-1B visa holders make up a large portion of America's highly skilled workforce, especially in the technology sector. Many of these workers are from India, forming one of the largest immigrant communities within the U.S. labor force. Under the new rule, officials may examine publicly visible posts on social platforms such as X, Instagram, and LinkedIn. Their goal is to verify the consistency of information provided during the visa process. For example, if a person lists a particular job title on their social media profile but submits different details to the embassy or consulate, the discrepancy may raise questions. Immigration attorneys warned that even routine comments, shared articles, opinions about workplace matters, or professional updates on LinkedIn could theoretically prompt additional review during visa processing. The U.S. government says the rule is designed to ensure accuracy and transparency, and that it applies only to publicly accessible posts, not private messages. However, across many immigrant forums and community groups, people are expressing concern. Some fear that old posts, harmless comments, or ordinary interactions could be misunderstood. Others worry about whether their digital footprint might delay visa approvals or trigger unnecessary scrutiny. As the deadline approaches, many applicants are reviewing their social media history to ensure it aligns with the information they have provided in official visa documents. So, immigration experts are advising applicants to make sure their social media accounts reflect accurate, professional, and consistent information. For employers in the tech sector, this rule change, well, it may affect timelines for onboarding new workers. Together, these two developments, the self-deportation warning from ICC and the new social media review rule from the State Department, signal a broader shift in U.S. immigration policies. Enforcement is, becoming more digital, more automated, and more interconnected with public data. Federal agencies are using technology not only to identify people who are unlawfully present, but also to verify the details of those seeking legal entry or work authorization. These changes, honestly, underscore the importance of accurate information, legal compliance, and transparent digital footprints. Across the country, advocacy groups are urging individuals to stay informed about their rights. Legal organizations emphasize the importance of seeking professional advice before taking any major action, such as voluntarily leaving the United States or, altering public profiles. As the situation develops, the message from federal agencies remains firm. Immigration enforcement will continue, digital verification will expand, and honestly, individuals should prepare accordingly. For millions of undocumented immigrants, these announcements bring new urgency to long-standing questions about status, family stability, and long-term plans for illegal immigrants working under temporary visas. The new rules introduce an additional step in an already complex process. This story will continue.